Good morning, class and professor. I decided to get up early this morning and record my presentation before I head off to work because today is my birthday, so I'm hoping to free up a couple hours so I can go out and do things. I also decided to do a PowerPoint presentation, even though it wasn't required, to give you something better to look at other than my tired self this morning. So welcome to my presentation, Plea Bargains, a Good Deal or Bad Decision. Approximately 90 to 95% of all cases are settled in plea bargains. There is much debate about the constitutionality and fairness of the plea bargain process from advocates and critics alike. Sometimes it feels like a game show and let's see what deal we can make. Are the accused really getting a bargain, or are they stealing a good deal or letting the deal steal from them? The most important job of the criminal justice system is to protect the constitutional rights of the accused while serving justice for the community. It is a delicate balance. But even after weighing the pros and cons of the plea bargain process, it still should be a functional part of the criminal justice system. What is the plea bargain process? A plea bargain is an agreement between a defendant and a prosecutor in which the defendant agrees to plead guilty or no contest. This agreement is a compromise, and the prosecutor might drop some charges or reduce a charge to a less serious offense, or sometimes will recommend a specific sentence. This negotiation usually gets the defendant a lighter sentence and the prosecution a win, all without a trial. The plea bargain agreement is done between the lawyers of the prosecution and defense. The defense lawyer should explain all options to the accused and explain the terms of the plea bargain. This is to ensure it is a valid plea bargain. If the defendant is coerced, uninformed, or not competent to enter into the agreement, then the agreement is not valid and the judge can deny the plea bargain. It is the decision of the accused if they want to agree to the plea bargain. It must be voluntarily made. It must be on a factual basis as well. If all the terms are agreed on between both parties and accepted by the defendant, then it is presented to the court. The role of the judge is typically limited. According to Cornell law, in most jurisdictions, however, judges' roles in plea bargaining is limited. For example, federal judges retain final authority over sentencing decisions and are not bound by prosecutors' recommendations, even if the recommendations are part of the plea bargains. So typically the sentencings are recommendations. The judge can decide upon himself if they want to agree to that or not. Most judges do not participate in the plea bargain process directly, and when the bargain is presented to the court, the judge typically goes over the rights of the defendant, and if he wants to waive them and enter the plea, the judge normally covers the terms of the plea bargain to make sure the defendant is agreeable to these terms. The judge also sentences the defendant. Typically, it is in accordance to the plea bargain. However, in some jurisdictions, the judge has the option to sentence according to his discretion, but typically they keep the plea bargain agreement. For fairness of this argument, I would like to do some comparisons of pros and cons of the plea bargain process. Some critics oppose plea bargaining. According to Cornell law, they feel that the plea bargain allows the defendant to skirt responsibility for the crimes that they have committed, basically not holding them accountable or the consequences that they deserve for the actions that they have committed. Also, others argue that it's too coercive and undermine important constitutional rights, and this is according to Cornell law as well. One of the readings we were assigned also stated the plea bargain presents an unconstitutional condition, problems, and places an impermissible burden on several fundamental constitutional liberties. I found through researching on my own another paper that states written by Devers that states the plea bargain process has been criticized for allowing prosecutors too much discretion compared with judges who are held to concise sentencing guidelines. Another con is that innocent people plead guilty because trials are unpredictable and they have a fear of getting a harsher sentence. Guilty people get lighter sentences. The pros of the plea bargain process. It allows the criminal justice system to conserve resources. This is according to Cornell law. So basically, they're saving time and money in the criminal justice system. Some argue the plea bargain process is more cost effective than having all cases go to trial. Furthermore, some researchers and legal scholars have reiterated the practice is fair, just, and procedurally sound. And this was according to the research paper that I found, written by Devers. The defendants tend to get a better deal than if they go to trial and lose. Also, the Supreme Court, in numerous cases, has held that plea bargainings are constitutional. They also are an essential part of the criminal justice system that can be beneficial to both sides. So, with all this being said, the two biggest arguments against plea bargaining are the lack of consequences for actions and people lose their constitutional rights. The defendant is still sentenced, just not as harsh. There has always been discretioning in sentencing, and it is the norm for the court to be lenient. So lighter sentencing is not necessarily a new or abnormal concept. Waiving constitutional rights is not either. The accused can waive their rights during interrogation by law enforcement, so having a lawyer help them broker a deal seems less coercive and more of a protection of their rights. Both sides, the prosecution and defense, tend to benefit from the plea bargain process. The criminal justice system benefits as well since it conserves resources. With a few reforms, the plea bargain process would be an even more valuable tool for the criminal justice system. Another key argument is about innocent people pleading guilty and prosecutors' overreach. And these arguments I'm going to save. I found some good points that I'd like to make, but I'm going to save those for some responses that I make to other people's debates. So I look forward to being able to present these points to you as well. In summary, I'd like to say plea bargains are a vital part of the criminal justice system, and in most situations, there are pros and cons in almost every situation. So we should keep the pros and work on the cons of the situation. Granted, the plea bargain process could use some reform to prevent overreach. However, to do away with it, I feel would be more detrimental. These are my resources that I use, my references, and I hope you enjoyed the presentation, and I look forward to debating with you all in the rest of the discussion post. Have a good day, everybody.